At the request of our colleague Senator Duplessis, we will move now to Senate Bill 218 by Senator Duplessis. Thank you, ma'am. Got you. All right, Senator Duplessis. We have Senate Bill 218. Please begin, sir.
Thank you, Chairman. Good morning, committee. Senate Bill 218 is not an unfamiliar bill. We brought this bill last year, and to many of you, it's certainly not an unfamiliar concept. Back in 2018, when I first got to the legislature, serving in the House, one of the first votes that I took in House criminal justice was on a constitutional amendment that would allow the state of Louisiana to change a really bad history of allowing people to be convicted by non-unanimous juries. We as a state did the right thing. I believe it was 64% of the voters voted to ensure that in order to be convicted in this state, it had to be by a unanimous jury. And we all agreed that that was the right thing to do. And I'm sure that everybody today agrees that that is the right thing to do. But we knew at that time there were still several hundred cases of individuals who were serving sentences from convictions stemming from non-unanimous juries. So in many ways, it was the right step forward, but it was not a complete step. And this bill is an attempt to complete that step. As I've said before, this is not something that we can ignore. This is not something we can sweep under the rug, as convenient as that might be. It's just something we cannot do. So I realize that SB 218 might not be the easiest for some, but in many ways it's very simple. And I want to just kind of tell you why I believe SB 218 is simple. What it will do is that it would give every person who has been convicted by a non-unanimous jury the opportunity, just the opportunity, to petition for post-conviction relief based upon that non-unanimous jury conviction. It's not a get-out-of-jail-free card. They have to prove by clear and convincing evidence that they were indeed convicted by a non-unanimous jury, and the district attorney still holds the discretion whether or not to agree to allow for there to be a retrial. As you know, district attorneys throughout this state try cases every day. They have retrials every day. They try cases from decades ago every day. Right now, Louisiana remains the only state in the country to incarcerate individuals who were convicted by non-unanimous juries. The other state who had this similar practice was Oregon. When they changed the law in Oregon, it was also made retroactive. Now, Louisiana did not do that. The U.S. Supreme Court, as well as the Louisiana Supreme Court, left it up to the legislature. They didn't order us to do it, but they left it up to the legislature to correct this injustice. And that's what it is. It's an injustice. As I said, this bill will provide a new trial, or the opportunity for a new trial, only if the individual convicted by a non-unanimous jury can prove it by clear and convincing evidence. This will ensure a fair, equitable, and just process for everyone affected, even the victims. It allows the district attorney the discretion, and again, it is not a get-out-of-jail-free card. We currently have mechanisms in place, and we have a process in place for retrials, even when a lot of time has passed. When it comes to the argument, because you're going to hear arguments from the District Attorneys Association as to why this would create inefficiencies and why it would be hard for the state to retry a case because there might not be victims that are available. It's important for this committee to know that Louisiana law allows for DAs to enter testimony on the record and evidence on the record from previous trials. So think about what that means. If you had a witness who testified against a defendant and it was used to convict that defendant, that same testimony can be read at the retrial. But here's the major distinction and why it favors the state. It favors the state because you cannot cross-examine the witness. You can't ask the witness questions, so you basically just have to take the testimony as it was given from the trial, which may have been 30 years ago. So that's actually a benefit to the state, and that evidence can be used in the retrial. So when the DAs try to come to this table and say that they'll be at a disadvantage, it's just simply not true. More time can also be given to the DAs to decide, in order to decide whether or not to even re-prosecute, so they can effectively manage this influx or supposed influx of cases with all the due diligence that they need. This state, Louisiana, has always been pro-victim, and we have prepared ourselves to assist victims in this process and making those systems available if and when that time comes. And on the cost argument, let me be clear. The suggestion that creating a separate panel, another layer of bureaucracy as a more efficient means to deal with this is a completely backwards argument. That would be even more inefficient and more ineffective, and we know that because when this has been attempted in the past, I don't remember if it was 2021 or 2022, on the House side, former Representative Randall Gaines had that bill, and it basically became a disaster. It became a train wreck. This is the cleanest way to do it. This is the most efficient and effective way to do it. We already have a post-conviction relief process in place. This just says that we as a state agree that juries that were rendered non-unanimously are indeed unconstitutional. And because we believe that these these convictions were unconstitutional, we're going to give the courts and the DAs an opportunity to review these cases and potentially grant a retrial. There's also the opportunity to plead to a lesser offense, right? A lot of these cases are several decades old. So think about if a person was just arrested for a new crime, let's say the case was 20, 30 years old, and your local DA is reviewing this case and they have to make a decision on what they want to do, and the defendant chooses to plea, they're going to take that plea every day before they go to trial. So I'm saying, what's the difference here, right? So again, I know you're going to hear a lot of arguments as to why this is so complex and complicated. It's really actually very simple. The question is, are we going to just do the right thing? And I think it's time for us to do that. I'm certainly here to answer any questions that you may have, but I know that there are many people who are here to speak. So with that, Mr. Chairman, I appreciate the opportunity to present this bill.
Could you just walk me through the mechanics again? So currently incarcerated, and being the non-lawyer on the panel, currently incarcerated, who do they apply to?
They petition the court in the parish where they were,
where the conviction
happened.
Where the conviction occurred. Okay.
And I also want to be clear. I have a list of cases before me, the numbers. There was a lot of research, a lot of work, a lot of effort put into the numbers in terms of where the cases are pending out of. We're looking at roughly 773 cases. It's my understanding Oregon had 793 cases. Their courts did not come to a screeching halt. Their court was not overloaded, and it's going just fine. The numbers are as follows: 141 in Jefferson, 96 in East Baton Rouge, 88 in Caddo, 78 Orleans, so on and so forth. So the parishes with most population, it's pretty congruent with the number of cases. When you get down, a lot of the parishes have very few cases, if any at all, okay? And the parishes that have the most cases have not been the most vocal opponents to this legislation, okay? So I just want us to keep that all in context as we think about this, where these cases are going to be coming from when we talk about the system being overwhelmed, because that's just not going to happen.
So do you define the process in your bill then? So somebody currently incarcerated, they make a plea with the district court in which they were convicted, then the district court is compelled to hold a hearing related to that?
They're not necessarily compelled. The DA still the DA still has to participate in the process. And the DA still has a level of discretion where they can not agree to it.
Prior to a hearing being held at
Correct.
all, or is that, and that's defined in your bill that they,
No, what my bill does is it just simply, as you can see on page 2, it will not be deemed repetitive if a defendant were to file an application for post-conviction relief on these grounds. Currently in the law, it's not allowed. This would basically be a waiver of that, and then they would be able to make the repetitive motion for post-conviction relief.
and then is that appealable? So if they make that motion with the district court, maybe the district attorney files something and says, we're not in support.
Currently
of
under
a
law, I
rehearing.
don't believe it would be appealable.
Okay.
But the attorneys who are going to speak after me can speak to that. But currently, I do not believe that it would be appealable. I don't even believe it's a right at this time.
Okay. Thank you for taking my question. Senator Bowie has a question.
Thank you, Mr. Chairman. Senator Duplessis, could you explain to me why the 773 individuals were not afforded the opportunity for post-conviction relief?
Why they were not afforded the opportunity for post-conviction relief currently? Mm-hmm. Okay, so when the bill was passed back in 2018, because remember, the law as it stood allowed for you to be convicted by a non-unanimous jury. Mm-hmm. When the Constitution was changed, it was only done prospectively. Mm-hmm. It was only done prospectively. So because there was not any language in the amendment that made it retroactive, mm-hmm. that right was not allowed to them. So then, of course, all of this had to be litigated. Mm-hmm. And then there was a case that went up to U.S. Supreme Court called the Ramos case, where the U.S. Supreme Court indeed declared that non-unanimous jury convictions were unconstitutional. However, it did not order the state to go back and make it retroactive, to give them the opportunity to petition for post-conviction relief. Mm-hmm. So they were never granted that. In law, they were never granted that opportunity as a way to petition.
Okay, so in just simple language,
Yeah.
the ruling did not afford a retrospective application
Retroactive,
of
yeah. Mm-hmm.
something that we deemed was injustice.
Yes.
And this bill actually says that now in Louisiana, we want to give every citizen who was not afforded that opportunity for justice.
Right, and I want to reemphasize on that question because that's a very poignant question you asked. Both the United States Supreme Court and the Louisiana Supreme Court left it up to the legislature. Mm-hmm. They never prohibited us from doing it. In fact, they said that they are not the legislature. It's up to the legislature to do the work, and that's what this bill is here to do.
And the bill only affords the right to petition.
That's correct.
Does not guarantee.
Absolutely not.
A simple matter of right versus wrong and justice versus injustice.
That's correct.
Thank you. I have no other questions.
Thank you, Senator Bowie. All right, the board is clear. Senator Duplessis, if you would like to move into testimony from those in support wishing to speak.
Yes, sir.
Okay.
All right. I'm going to move, get out the way.
Okay. All right, we'll now move into testimony from those in support wishing to speak, and we'll take 3 at a time. We'll start with Terry Landry from SPLC, my friend Matt Bailey from Metairie, and Ronald Marshall with Vote. These are in no particular order. If any of you have an order you wanted to come up in together, we can certainly be flexible in that regard as well.
I'm first.
Yeah. Let's see. We have the other individuals who had asked in that group, Terry Landry and Ronald Marshall.
Terry's in the hall.
Terry. All right. I think they're going to try to get them, so we'll go ahead and start before we call anybody else up then. Welcome to the committee. Please introduce yourself for the record.
Thank you. Matt Bailey. I'm a resident of Metairie in Jefferson Parish, originally from Gina and LaSalle Parish. I'm a father. I'm a veteran of the Louisiana Army National Guard, and I'm a survivor of a violent crime that happened in 2012 in Shreveport. I was forced into my car at gunpoint and made to drive around, go to 2 different ATMs, and after about 20 minutes, the guy got out and walked away. Unfortunately, in that ordeal, I never got a good look at the individual. He was kind of behind me at all times, so I really wasn't a great witness for my own situation. But there was a man who was convicted for that crime and was sentenced to 35 years in prison. He's in prison in Avoyelles Parish right now. He was convicted on a non-unanimous jury verdict. And I had a really bad feeling in the pit of my stomach about that whole situation, frankly. I'm here to ask that you seriously consider voting to send this bill to the full Senate. I believe that it's time for it to have a larger conversation around this matter. And I want to just reemphasize that this does not open floodgates. It just provides an opportunity for justice. We all know that it's well established by the voters of this state, by the United States Supreme Court, that anything other than a unanimous jury verdict is unjust, is unconstitutional. And I think this is the year, this is the opportunity for this bill to go and be heard before the full Senate and hopefully go and be heard before the full House. And I certainly hope that we don't elevate the concept of convenience or efficiency to the same level as the concept of justice. And, again, as a citizen of this state and as a survivor of crime, I'm asking you to vote yes on this bill.
Thank you. The board is clear. Thank you for your testimony, and it's always nice to see you. Now, we had 2 other folks in that group. Did you locate? Okay, they waived. Okay. All right. So Aaron Bindley with the Pelican Institute, Tom Costanza with the Louisiana Conference of Catholic Bishops, and Bruce Riley. And Bruce waived. Okay. All right. Is Tom here? Yeah. And Danny Trahan. Excellent. Welcome to the committee. Thank you very much. You may go in any order you choose to proceed in.
Thank you, Mr. Chairman. Aaron Bindley with the Pelican Institute for Public Policy. I'm happy to be here today and want to thank Senator Duplessis for bringing this important legislation. And we are here in full support of it and would urge you to move this favorably. A lot of times you hear us come to the table and we engage in discussions about our mission, which is to ensure that every person in Louisiana has the ability to thrive. And most of the time that presents itself in policy discussions about free markets. I would say we probably don't have enough opportunities to talk more about other things that we really care about and think are central to that goal, which have to do with individual liberties and constitutional rights. So this is certainly one that is very important in that regard, something that we have long followed and really felt strongly that this is the direction that the state needs to move. One, because it's the right thing to do, and because of the way that this bill is set up in terms of the process. We think that this offers a very responsible, efficient, cost-effective process to be able to consider these requests as they go forward. And for that reason, we think this is a responsible way to move forward and to do the right thing, as Senator Duplessis said. So with that, I won't belabor the point, but we are here in support and would urge you to report this bill favorably. Thank you.
Thank you very much for your testimony. Yes, sir.
Thank you, Chairman Reese. Tom Costanza with the Louisiana Conference of Catholic Bishops. And just in general, the Catholic Church believes in restorative justice principles. So that means restoring the victim. That means restoring the offender and the wider community. So that's really a framework that this fits in. So it was good that Louisiana did the right thing in 2018. We always want to keep in mind the victims, and I appreciated the testimony. I think this is an opportunity to move forward as a state, to do the right thing. We know that restoring, our reentry programs are good. If we do these court cases and they come out, we have a good history of reentry. So I think for us, it's within the realm of restorative justice that we restore the victim, the offender, and the community. So we'd ask you to approve this. Thank you.
Thank you very much for your testimony. Yes, ma'am.
Hi. As a former Project Queen, I would normally represent myself as, hi, my name is Danny Tronholm, proudly representing the state of Louisiana. But today, I can't say that I'm so proud to represent this state because of this injustice that we face. I am the founder of Fight for Your Light Ministries, and as I speak, I just want to keep this phrase in mind. It takes 1,000,000 miles to fight for your light, but what if your light leads the way? Would you continue to fight? You, as legislators, hold the power in this position, and we all know that. I thank you, Mr. Royce, for even bringing this to our attention and going against the grain. I am all for this bill, as they keep saying that, in 2018 or 2016, whenever the Ramos case was brought to our attention, that it only affected the people moving forward. Well, we know that life is lived forward, but it's only understood backwards. So it's not fair for the people that's still in prison today to still suffer while time has changed, life has changed, and these people actually get access to it. I believe that if we're going to be a fair state, that everybody should, and we know that Louisiana is one of the only states that still has this, and it hasn't become retroactive yet. So I pray that you would do a deep searching within your soul before saying yes or no to this bill, and know that you have the power to do this. Yeah, I think that's all I got. Thank you so much for your time.
No, thank you very much, all three of you, for being in the committee today and for sharing your testimony. Thank you.
All right, thank you.
All right. Next up, we have Devin Williams, Herman Evans, and Jermaine Hudson. If you would come forward and provide your testimony. Welcome to the committee today.
Morning.
Ma'am,
It's
would you
okay,
like to
I'd like
begin?
to ask, yes, and I also like to ask that this letter be distributed, please.
Yeah, please do. Yeah.
Good
Welcome
morning.
to the committee. Please introduce yourself. and
Yes.
You may proceed.
First, I want to thank you all for this opportunity to speak with you on this issue. My name is Devin Williams. I'm from Shreveport, and I'm here today in support of Senate Bill 218. My family is directly impacted by non-unanimous juries, and my brother has been incarcerated for almost 17 years now. Losing my brother at such an early age completely shifted the trajectory of my life. I was 13 years old when my brother was arrested, and he was 16. So when I became of age, I assumed the role of his primary advocate, and I've continued to provide financial and emotional support throughout his incarceration. With that being said, I've witnessed firsthand so many detrimental things, both inside of that prison and inside of my family. I've been testifying on this issue for 4 years now, and with each passing year, time continues. Life still happens. Death still happens. Our loved ones are missing invaluable moments to share with family. Unfortunately, we've become collateral consequences to an archaic rule with racist origins. And I'm afraid that if we continue to operate in a criminal justice system that does not ensure wrongs are corrected, we may very well be heading towards a generation of individuals who do not trust the criminal justice system. I do not believe the severity or the complexity of this issue is lost upon this esteemed committee. And I humbly ask that you take heed to what Louisiana voters said in 2018, and as well as how the courts have deemed these type of convictions unconstitutional. And before I leave you, I just want to express that impacted families are willing to do whatever we can to provide any support that you all may need when considering this decision. Thank you.
Thank you very much for your testimony. Yes, sir. Welcome to the committee.
Hi, y'all doing? My name is Herman Evans. I was convicted by a 10-2 jury. In 1988, I spent 37 years in prison for a crime I didn't commit. I testified today because the Senator Owens asked me to. I spoke with him. It is hard. It's not hard for me to speak about these 37 years that I've done in Angola, because at the time, my father passed since I was there. I lost a daughter, 3 sisters. I don't have an auntie or uncle on neither side left. Every time I tried to make my voice heard in my 37 years, I kept getting one word, denied. But I'm asking today that we don't get this one word denied, that you may do a good job on this city day. My job at Angola was working, cutting the grass, and Point Lookout, a cemetery at Angola, praying every day. I don't die in Angola, where I can get out and be with my family again. So I just prayed and asked God, and He blessed me to be able to do that. When Ramos' case had come about, I was told that my conviction was unconstitutional. So first, like, it didn't really matter, because you know how they would normally do. But I kept on, and then at the time, when Ramos was decided, I just kept praying, kept asking God to remove that and me to go back home to my family. And He granted that. Today I'm grateful that I'm home today. And I left a lot of people behind that deserve a chance to have their convictions, them unconstitutional convictions, overturned, or at least a chance at it. I pray and ask that y'all do this today, that y'all do the right thing. Because, man, there's a lot of families that's messed around because of unconstitutional thing. And they have other innocent people that I know in there right now with the same thing. Thank you.
Thank you for your testimony, and I also want to thank you for being in the Capitol last week. And I know that you spent a good bit of time visiting with some of our colleagues and sharing your testimony and your story with them, and very much appreciate your effort in that.
Thank you.
Yes, sir. Thank you.
Good morning. My name is Jermaine Hudson. I was convicted by a non-unanimous jury back in 2000 for a crime that I didn't commit. I received a 99-year sentence for that crime. Upon getting my conviction overturned in 2021 by the courts for my non-unanimous violation, before I can even go plead guilty, because I was going to plead guilty just to get a chance to get my freedom back, even though I didn't commit the crime. But thanks to this man for coming forward with the truth, to say that nothing never happened to him, that he made up the whole story. I'm here today to support this bill because you have a lot of guys and women that's in this same predicament, that deserve a chance, that deserve a shot at getting their voice heard, that deserve a chance to be free. You know, I thank God that I'm here today, because just like my fellow brother, I lost a lot of family. But thank God, my children are creating more. You know, they're building my family tree up. And I thank God that I lived throughout that storm, lived throughout that hardship of going through a sentence, a crime that never took place. To go through that, to experience that, it's one of the worstest feelings any man or woman could ever feel in their life. To know you're incarcerated for something you don't have no idea of what's going on. But again, I thank this guy. I thank him with all my heart for being courageous to come forward, to say nothing ever happened to him, that he made up the whole story. So I'm here today to ask you guys, please give these men and women a chance. Give them a chance at their freedom. However it turns out, give them a chance. Give them a shot. They all deserve it, because I witnessed a whole lot of them that was in my situation that's innocent. They don't want to go back to trial. A lot of them don't want to go back to trial. A lot of them want to just plead guilty and get on with their life. The percentage, since I've been home, is a big percentage because 98% of the guys that was released and women that have been released since I've been home are doing exceptionally good. They got families, they'll move forward, they've moved on with their lives, and I'm proud of them. So I ask you guys today to please do the right thing. Give these women, men and women, a chance. Thank you.
Okay. Thank you, and thank you for your testimony, being here today, all three of you. Thank you.
Thank you.
Our next group will be Bobby Gumpright, Claude Michael Como, and Will Snowden in support, wishing to speak. Welcome to the committee, and I'll just say that I appreciate Mr. Gumpright being here back from my district and the exemplary job that you're doing in giving back to the community and providing opportunity for people that were incarcerated as they exit that system and kind of get reestablished in life, and the work that you're doing to make that possible and treatment facilities that you're trying to facilitate has been very impactful in our community. So thank you for spending your time since you've been out to do that. So thank you.
Thank you.
Y'all can go in any order you'd like.
Go ahead.
Just introduce yourself for the record. And
Good morning, Chairman and members of the committee. My name is Bobby Gumpright, and I live in DeRidder, Louisiana. I come before you as a citizen of Louisiana, a recovery counselor, and a man of faith. I'm also a man who lives each day with the consequences of a terrible sin. In 1999, in the throes of my addiction, I falsely reported a crime in a desperate attempt to hide my failures. That lie, my lie, led to the wrongful conviction of Jermaine Hudson, a 20-year-old black man. He was convicted by a non-unanimous jury, a practice that has been since declared unconstitutional. Jermaine went on to serve over 22 years in Louisiana State Penitentiary for a crime he did not commit. I cannot describe to you the guilt of knowing that my actions helped put an innocent man behind bars. I'm not here to deny or minimize my part in this tragic miscarriage of justice. I am here to again publicly apologize and accept responsibility for my part. I cannot stand silent while so many more remain incarcerated under the same broken system that stole Jermaine's freedom. That is why I'm here today with Jermaine at my side to urge you to support Senate Bill 218. In 2018, Louisiana voters passed Constitutional Amendment 2, decisively rejecting the racist legacy of Jim Crow juries. In 2020, the U.S. Supreme Court confirmed in Ramos versus Louisiana that non-unanimous jury verdicts violate the Sixth Amendment. But just 1 year later, in Edwards versus Vanoy, the court ruled that the decision would not apply retroactively. That ruling left men like Jermaine and hundreds of others trapped by a legal technicality. And in State versus Reddick, in our own Louisiana Supreme Court made it clear, if justice is to be done, it must come from the legislature. That means this body has the responsibility and the opportunity to correct the mistake made by the Louisiana legislature so long ago. Senate Bill 218 is your opportunity to act. This bill does not release anybody automatically. It does not erase convictions or silence victims. What it does is grant the right to review, to fairness, to be heard, a right that was never given to them in the first place. Now, I know the arguments against this bill. I've heard people say if the law required unanimity back then, they would have gotten it. Many of them have since admitted guilt during parole hearings, so why even revisit it? We could have a panel of government and judicial professionals decide which cases get a second look. Let me respond to those arguments. As to the requirement of unanimity, the problem isn't whether a unanimous verdict might have happened. The problem is it didn't. It didn't because the law allowed jurors to stop deliberating once they reached 10 guilty votes. We'll never know how many jurors had doubt and were pressured into silence, or how many would have stood firm if unanimity was required. That uncertainty is not justice. We don't convict on might. We convict on beyond a reasonable doubt. As for those who admitted guilt in parole hearings, many of them did so because it was the only path to freedom. Saying what the system wants to hear doesn't mean the truth was told. It means people are surviving. Even Jermaine, an innocent man, was ready to take a guilty plea just to get out of prison. Had I not come forward, Jermaine would still be in the probation and parole system due to an admission of guilt. And finally, to speak to the idea of a panel appointed to decide what gets a second look or not, that's what juries are for. We don't try cases with panels of bureaucrats. We leave that to a jury of peers. And if the evidence in the case is truly strong, and as Senator Duplessis says, that evidence is totally admissible, then let the state prove it under the standards that we now recognize as constitutional. That is not only fair, it's a fundamental to a justice system that we can trust. Senate Bill 218 upholds the rule of law. It does not undermine it. It does not open the prison gates. It opens the courtroom doors to those denied justice the first time. Jermaine and I now work together speaking about justice, accountability, and grace. He forgave me. And through that forgiveness, we are fighting for others who still wait for a chance to be heard. But Jermaine is just one voice. There are so many more fathers, daughters, veterans, sons of Louisiana, and they remain in prison not because a jury unanimously convicted them, but because a flawed system allowed an improperly informed jury to do so. A single voice won't find every answer, but 100 voices, each with a piece of the puzzle, can change the world. I couldn't change the past, but I could refuse to live the lie any longer while injustice continued. Louisiana can't change the past, but Louisiana can refuse to let its injustice live on. Thomas Jefferson once said, "Trial by jury is the only anchor yet imagined by man by which a government can be held to the principles of its constitution. When the jury itself is flawed, the anchor breaks." Senate Bill 218 is a step towards repairing it. Please, Senators, vote to favorably pass on SB 218 to the floor, not because it's politically convenient, not because it's easy, but because it's right. Let Louisiana not just confess its history, let Louisiana correct it. Thank you for your time, your attention, and your commitment to justice.
Thank you, Mr. Cumbright, for your testimony. Whoever would like to go next can introduce themselves and proceed, please.
My name is Will Snowden. I am a law professor that teaches at Loyola University in New Orleans, and I teach constitutional law. I teach criminal procedure, I teach criminal law, and I teach a seminar on criminal juries. I'm also the director of the Juror Project, and you may not be able to tell, but my pin says jury duty is my duty. Let's add those things up. Who am I? I'm a jury duty nerd, and I'm very, very excited to talk to you about this bill and its importance. I had the opportunity to speak with my mom. Tell you a quick story. I let her know that I was coming to the Capitol to talk about this particular bill, and she goes, well, what's the bill about? And I let her know it was related to juries. She said, "You're still talking about juries?" I said, "Yeah, Mom, this is my thing." And I was letting her know that this bill is giving an opportunity for people who were convicted via a non-unanimous verdict to petition and have their case looked at a second time. She goes, "Well, that makes sense, but didn't we change that? Didn't we require unanimous verdicts? Isn't that something that was passed in 2018? And I told my mom, I said, "Yeah, but when the bill was passed, it was prospective, not retroactive." She goes, "Well, why wasn't it retroactive?" I said, "Well, sometimes we take baby steps, and we're continuing to walk towards justice with this particular bill." She then asked me, well, what harms have been committed with non-unanimous verdicts? And I thought about a couple of things. I thought about the work that the Innocence Project of New Orleans has done and how they have highlighted that there's been at least 13 people who were originally convicted via a non-unanimous verdict that have been exonerated. So what does that mean? It means that when those folks went to trial, there was at least one or maybe two people who voted not guilty. But because we did not require unanimity, they could not prevent an innocent person from going to prison to serve time for a crime they did not commit. We all know the injustices that happen when innocent people are convicted for crimes they did not commit. It is not only an injustice for that individual, it is also an injustice for the survivor of crime because they do not have finality. We as a community don't have accountability, and therefore we as a state do not have justice. I think about other harms that have come from this particular bill. The mechanism of non-unanimous verdicts. And I'm reminded of what the social science tells us about the deliberation process when we allow non-unanimous juries. What that means is that when we require non-unanimous juries, there's a different style of deliberation, meaning that the conversation that the jurors are participating in is different than when we require unanimous verdicts. My mom said, well, what does that look like? Well, I said there's verdict-driven deliberation, and then there's evidence-driven deliberation. My mom said, well, what's the difference? I said, well, evidence-driven deliberation is when jurors get into that deliberation room and they all share their perspective about the evidence that they saw, the testimony that they heard, and the arguments that were made. And then they vote. But verdict-driven looks like justice, where we do not necessarily only focus on the numbers. Because when we only required non-unanimous verdicts, the concern was how quickly can we get to 10? We've heard references to the case Ramos versus Louisiana, and I was hoping nobody would tell you this so that I could tell it to you. Ramos got a new trial. What do you think happened at that trial? He was found not guilty. He was originally convicted of a non-unanimous verdict. Went to trial a second time because the Supreme Court said non-unanimous verdicts are unconstitutional. This man gets a new trial. And when he got that new trial, and when unanimity was required, he was found not guilty. But imagine if Mr. Ramos did not have the luck of his case being on appeal when this was going up to the United States Supreme Court, he would not have had the opportunity to have his case retried. And so what we're thinking about with this particular case is how are we giving individuals who were originally convicted via a non-unanimous verdict an opportunity to petition their case to be reviewed a second time. I'm going to close with this. Nobody says this. Well, you might know this phrase, what's good for the goose is good for the gander. We know that our state has a state bird of a pelican. No one says what's good for the pelican is good for the pod. But what I think that means is what's good for individuals now that we require unanimity for cases going forward, for people who are charged with crime, that they have to be convicted beyond a reasonable doubt for all 12 jurors. It should also be applied for the individuals who have been convicted where unanimity was not present. Now, both my parents are teachers. They taught for 30 years. And I only have one request for you. You don't owe me any favors, but I'm going to ask for one. Ask me some questions. Because when my mom sees this and she says, well, if the committee didn't ask you any questions, you didn't do a good job. And I at least want to be able to get on the phone with my mom and say I did a decent job. So ask me a question. You can even ask me my birthday.
I'm going to say a couple of things. Number one, I need to get your phone number. And for all the constituents that call and say, I got jury duty, can you get me off of jury duty?
Listen.
I'm going to say, you got to call this guy first.
Please
and let
do.
him talk to you about your solemn obligation as a citizen to participate in the jury process.
Absolutely.
With the enthusiasm that you're presenting with today.
Yes, indeed.
Some people see it as a burden when indeed it's a privilege in our system of justice.
Senator Royce, you're preaching to the converted.
So maybe just walk me a little bit through procedurally, and again, as a non-lawyer, just trying to understand, maybe as you see it, that somebody makes an appeal or files with the district court for their case to be reheard under the provisions of this law.
Yeah, it's a great question.
What do you think the options available to that judge are?
Yeah. The privilege of being in this position is I get to loop in co-counsel. Because this is his expertise. And so I appreciate the question, and I think my mom will still give me points for it.
Good.
But I'm going to ask, if you don't mind, explaining the procedure, because I want to make sure it's absolutely clear.
Absolutely, I can do that. Senator Royce, so this bill operates on post-conviction relief. So there are certain grounds that you can bring for post-conviction claims. The Code of Criminal Procedure outlines those claims. This would add a new claim for non-unanimous jury verdicts. And so someone would be able to petition the court for that, for relief that way, and if they were to be granted, then they would be granted relief in the form of a new trial. So it also removes it from a repetitive application. Senator Duplessis was getting at that earlier. Many of the people that have non-unanimous jury verdicts have already applied for post-conviction relief, and because the Supreme Court didn't grant it, this could bar their claims. It also removes it from time limitations. So some of the old cases that may have run out of post-conviction relief on time can apply for it this method as well.
What do you believe the alternatives available to the judge are upon receiving that? Is having a new trial or not having a new trial the only alternative given to the judge, as opposed to other traditional, what I would consider like other post-conviction relief or clemency or, parole apparatuses? Are those available to the judge to consider as well?
So what the judge would do is look at the evidence that was presented to them, and what they would have to decide is whether that evidence is by clear and convincing standards a non-unanimous jury verdict. Then they would grant relief. The discretion then would shift more to the DA. The DA would have to decide whether or not they want to re-prosecute that case. The judge can't grant clemency because that's not a power that the judge has, but the judge does have the power to decide whether or not the evidence provided was enough to prove that this person was convicted by a non-unanimous jury verdict. And so they could offer an evidentiary hearing if they're not satisfied with what's on the briefing. They could give the DA a chance to respond and outline why they think that relief shouldn't be granted in this case. But if the petition is granted, then the option would be the conviction would be voided, and then it would be reset back to like a pretrial state where the DA would then have the discretion to decide what they want to do with that case going forward.
If a judge in receipt of this petition were to review the case file and see, and maybe this happens, maybe it doesn't happen, but they would see that upon polling of the jury, it was determined that the jury was unanimous on a particular charge and non-unanimous on another charge.
Right. So
how would that work?
Yeah, so that charge that was unanimous would stay. There would be no grounds to remove that conviction or anything like that. It would only apply to the conviction that was non-unanimous. And I mean, there are some cases where someone has a non-unanimous conviction on one count, but a unanimous conviction on another count. And even if that conviction was voided, the unanimous conviction may mean they remain in prison for life. And so it wouldn't affect that situation particularly. So it wouldn't affect any conviction that wasn't non-unanimous.
Okay. Thank you for your testimony. You may have another shot to impress your mother here. Senator McMahon.
Yeah, thank you for your testimony. If you could, can you walk me through the state Supreme Court's, ruling rationale as to why they kicked this back to did they speak to that at all in their ruling?
It's a reference to checks and balances, right? And thinking that as the application of the Ramos decision at the time, looking at Louisiana not requiring unanimous verdicts, that was a decision of the legislature. And so the court didn't feel it was their position to change what the legislator had originally done in terms of allowing non-unanimous verdicts and saying if this is something that the legislature wants to revisit, then that's something that they can do.
But that wasn't the case, right, in Oregon. Is that correct?
In Oregon, the petition was for the courts to review and apply this retroactively. And it's a good example.
Oh, that was by the petition itself?
The court granted the review for the unanimous jury requirement to be applied retroactively. The original decision from the Supreme Court didn't say that it applied retroactively. So Oregon, which had similar amount of cases that Louisiana did apply it retroactively. And my understanding is they're still working through those cases, but I haven't seen reports of a backlog or the system not being able to continue as intended.
How did they treat their, like Senator Royce brings up the example of while one count would be unanimous, another could be non-unanimous. How do they handle that?
With the same approach. So the case that has, let's say, more than one count. And on one count, it's a unanimous conviction. On another count, it's not. The only count that was reviewable or entitled to the retroactive applicability was the count that was retroactive.
Are district attorneys, like if the primary count was unanimous and that individual, was sentenced to life, are they still choosing to go back and re-prosecute the non-unanimous case? Does that make sense?
Yeah, so what it sounds like you're asking is, say, on one of the, let's say somebody's charged with 2 counts, one count, the person is convicted unanimously, and that person was sentenced to life without parole, and then on a second count where there was a non-unanimous conviction, that would be the count that they would have a new trial for. I haven't heard reports from district attorneys in terms of what they're doing, but understanding what makes most sense is, since the person is already convicted unanimously on a charge that gives them a life sentence, they can likely offer some type of a plea deal, or perhaps not even pursue that second count if they didn't need to. That would have not much of an effect legally as it relates to what that person's sentence is going to be. Symbolically, it would have some representation, but since that first conviction is for a life sentence, there's not much going to be happening for that individual.
In the instance that somebody is convicted of a non-unanimous jury and on all counts or one count, and that case is then sent back to the DA to reconsider whether they're going to prosecute on similar charges or
the same
charges. Yeah. What happens to that individual while the DA is trying to determine? I mean, do they remain in prison?
They're still incarcerated. There's nothing about this particular bill that says the person gets released and until the DA decides what they're going to do, because their conviction is still finalized. It isn't until the petition has been granted to review the case a second time. And then we would have all the mechanisms of pretrial incarceration in place, such as bail bonds and things along those lines.
Does the district attorney have a certain period of time to re-prosecute?
From a statute of limitations perspective? It's a good question, not one that I have the answer to. I believe as part of the petition, a defense lawyer would probably be willing to waive statute of limitations for purposes of giving a second shot, but I don't know the answer to that. Are you familiar?
Yeah, I mean, statutorily, there's a year time limit where to bring that charge again, but...
Is it a year from when the judge determines that they were convicted on a non-unanimous jury, or is it a year from, like, say, this law passes?
It would be a year from the time a judge voided the conviction,
and
not from the law.
Does a judge have a time frame that he would have to make a determination whether, or is it just a petition based on the filing of the defense attorney? Is that right?
Are you talking about the post-conviction relief application?
Yes.
There is not a timetable for a judge to respond to a post-conviction relief application.
Do you know the percentage of case? We're talking 700 and something. What was the number?
773.
773. The percentage of that, or number of that 773 that was convicted on one count being unanimous and one non-unanimous?
I don't have a percentage on that. I'm not sure. We don't have a percentage that would give it a multiple count thing. I know that a lot of the cases are not in that situation where like there is one unanimous case, but I couldn't give you an exact number.
Okay. Okay. Thank you. Thank you, Mr. Chairman.
All right. Thank you, Senator McMath. All right. The board is clear. Well, I guess you still have testimony. Sorry about that. Sorry about that.
And I've already hit some of the things that I was going to talk about. But my name
please
is
proceed, and just in case we didn't get you introduced on record a minute ago, please introduce yourself on the record.
My name is Claude Michael Como. I'm a staff attorney at the Department of Justice Initiative, and my plan was to operate on telling how the bill mechanically would work. So I do want to point out some things. I think we've talked about what happens in the post-conviction relief process. If this was granted, if a new trial was granted, the DAs then have the discretion to decide, are we going to re-prosecute? They could they could go back to trial if they wish to go back to trial, and then they could also offer a plea deal. A plea deal is offered. A plea deal is how 95% of all cases are resolved nowadays, and many people that have been convicted by non-unanimous juries were offered plea deals previously, and there's no reason why they couldn't be here. And I know that there's been an alternative floated by the District Attorneys Association for some sort of extrajudicial panel that would allow, that would decide whether or not there's other reasons as to why someone should be given relief. And I think this is one of those issues where the Supreme Court said that they don't want to act as a super legislature, where the legislature would be acting as a super judicial body in that case. It has no real oversight, and there's no ability for the petitioner then to present new evidence, cross-examine witnesses, or do anything they could during a normal trial. And there's a lot of problems with that. That fundamentally misses the issue in that we know what the injustice was. It was a non-unanimous jury vote. The Supreme Court's already told us what the injustice was. And so asking a petitioner then to go back and find other constitutional violations and other injustices that happened to their case is fundamentally unfair to give relief. Secondly, if the district attorneys are saying that there is an overwhelming amount of cases for them to spread out across all these different parishes, I can't imagine that it would be more efficient than to assign a small panel than to assign the same amount of cases and say that that's more efficient. That seems extremely unlikely. And to be really clear, the Louisiana district attorneys have done this before. The Supreme Court has already made them review cases that were on direct appeal when the Ramos case was decided. And they went through the same process. They decided whether or not they were going to re-prosecute a case. They decided whether they were going to do a plea deal or dismiss the case, whatever they decided to do. We talked about Ramos himself, who was given a new trial and was acquitted afterwards. And the courts were not overwhelmed there. Also, Oregon has been doing this already. They have granted retroactivity already and have been just fine. They have not been overwhelmed. You haven't heard any reports of their court system on fire. And there's really no logical reason as to why Louisiana wouldn't be able to do the same here. And the District Attorneys Association has expressed some concern that it would be difficult to retry these cases, that some of the witnesses might not be able to testify or some evidence might be lost. But that cuts both ways. Like, the defendant is also missing evidence that it could be lost to time, witnesses that have been lost to time. And as we've mentioned earlier, they lose the ability, like if the district attorneys read in testimony that they have from a previous trial, there is no ability for the defendant in that case to then cross-examine that witness. It's a piece of paper. And so that difficulty doesn't really match up with the reality of the situation. And frankly, the state has the burden to prove beyond a reasonable doubt that the person accused of a crime committed that crime in order to obtain a conviction. And the state has failed to do that in every single case that we're talking about here. And the Constitution designed this system to be difficult because the only way to ensure that we do not incarcerate someone that is innocent and strip them of their freedom. Louisiana's system has been serving justice with an asterisk and has been incarcerating people for over a century by cutting corners. And the difficulty of fixing that problem should not be a reason to continue doing nothing to solve that problem.
Can you tell me, we briefly touched on this earlier, but so in a situation where this petition's been filed and the district attorney says we don't have the availability of the evidence, or we don't have, for whatever reason, we disagree and we do not want to re-prosecute this case, does that end that appeal to the court? Or can the judge decide unilaterally to proceed with a new trial anyway? Or if the judge takes that information from the DA and the judge says I'm not going to demand a new trial, this case for whatever reason, what is the process available to the individual?
So the first process would be post-conviction relief. So this process would allow a judge to say, hey, this person had a non-unanimous jury verdict. We're going to grant this post-conviction relief application, and then and order that the conviction voided, and then you're in that pre-trial state. When the DA decides whether or not they have the evidence to re-prosecute at this point, it wouldn't be the judge deciding whether or not they have the evidence, it would just be the DA at this point deciding whether or not they have the evidence to re-prosecute this case. They could choose not to go back to trial at all. They could choose, I don't know, this case is
At that point, though, is the conviction just vacated?
The conviction is vacated, but the person would still be incarcerated, and then the DA has to decide whether or not they're going to re-prosecute. They could choose to dismiss if they feel like the evidence isn't strong enough to convict someone, which should have occurred back then, but they had a lesser burden of proof.
Right.
But it would all be up on the DA whether or not they're going to choose to re-prosecute or then dismiss or offer some kind of plea deal. Those would be essentially the options at the DA's disposal, but they have all of them.
Okay. Thank you for answering my question.
Absolutely.
I may have interrupted you as well.
Nope, you did not. I was
Okay.
just finished.
Okay. Well, thank you all very much for your testimony. It's been very engaging and very informing. So I certainly appreciate that. And then I'd like to get your number later to
Yes, indeed.
start giving to my constituents on jury duty.
You got it. Thank you.
Yeah, thank you. All right, we have Valerie Jefferson in support wishing to speak. While Ms. Jefferson comes up, we have cards in support, present to provide information if requested. Amy Richard, Mike McClanahan, and Erica Navalance with the promise of justice are available if requested. Welcome to the committee. Please introduce yourself for the record, and you may begin.
Yes. Hello. I might be a little nervous. This is my first time.
It's okay.
Hello, my name is
It's
Valerie.
a friendly crowd.
My name is Valerie Jefferson. I am the chairpresident of the Women of Action, ATU, a Women Caucus in New Orleans, Louisiana. ATU stands for Aggregated Transit Union. I am the chair labor of NAACP, a Louisiana conference. We are here in support of this bill. Let me tell you the reason why. Mm-hmm. The Women Caucus, we support families. We started back in 2005. Lately, we started partnering with different organizations that help and train younger adults, the next generation. I'm young too, but younger than me, right? So, but nevertheless, we thinking that our parents gave us the baton. It's now for us to train the next generation like we was trained. So we try to show them a productive way to be productive in the city, or be productive citizens. And when that person make a mistake and they feel that they have not been justly done or justly treated according to the Constitution, according to their beliefs, according to the community, according to the legislator, they feel disvalued. And God made everybody important. He created everybody in His image. Therefore, justice is in the Bible. So justice needs to be heard through the Constitution, through the legislature, and through the committee, through the community, through the city and the state. That's why we are sitting here today, me, myself, representing the Women Caucus and the labor of the NAACP, because we want a person to have a chance at every chance they can get for justice to be heard. That's why we are asking this committee to support this bill. I thank you.
Thank you very much for your testimony. You did great for your first time committee. Yeah. Okay, do we have a card from you? It's okay either way, but welcome to the committee. Please introduce yourself for the record, and then we'll make sure we have a card from you as well.
Hi, my name is Amy Richard. I am.
Okay, yeah, present, yes. Okay.
Yes, I didn't request to speak, but I was asked to speak.
Okay,
so
please do.
Thank you for asking.
Absolutely.
My fiance has been incarcerated for a little over 18 years. We grew up in Terrebonne Parish together. were friends for a long time. I respected him as a good man, good person. I asked him to be my son's godfather long before we ever were a couple. And I am a conservative. I did not understand how some things work in our criminal justice system until I saw what happened to him. And it quite opened my eyes. And I would have never believed it if I hadn't seen it for myself. I'm asking you to please listen to these voices today, because there's a lot of people and families that are hurting, knowing that innocent people are sitting in prison in our state. It is not a story. It is not a fairy tale. They are sitting in our prisons, and there's many. It's not a few. I had created a website to share with my friends on Facebook so they could understand the issue a little better, because a lot of conservatives don't. They don't, because they haven't walked through it. And I did a little research on Sir William Blackstone. He was a very highly regarded English judge, which most of our laws are, our law schools and our laws that were founded on his commentaries. And our founding fathers held very close to this, because we were a people that started a nation being oppressed by another nation. Sir William Blackstone said, this is called Blackstone's formulation or Blackstone's ratio: it is better that 10 guilty persons escape than one innocent suffer. And then I want to quote our founding father, John Adams. And he defended the British soldiers who were charged with murder for their role in the Boston Massacre. And he also expanded upon the rationale behind Blackstone's ratio or formulation when he stated, "We find in the rules laid down by the greatest English judges who have been the brightest of mankind, we are to look upon it as more beneficial that many guilty persons should escape unpunished than one innocent should suffer. The reason is because it is of more importance to community that innocence should be protected than it is that guilt should be punished. For guilt and crimes are so frequent in the world that all of them cannot be punished, and many times they happen in such a manner that it is not of much consequence to the public, whether they are punished or not. But when innocence itself is brought to the bar and condemned," this is our founding father of our country stating this. Please don't take it lightly. "Especially condemned to die, the subject will exclaim, 'It is immaterial to me whether I behave well or ill, for virtue itself has no security.'" I'm asking you to please listen. And if such a sentiment as this should take place in the mind of the subject, there would be an end to all security whatsoever. We have high crime rates, or did, in Baton Rouge and New Orleans. And I believe it's because there's been generations past that are disregarding our law because they have seen their fathers, their grandfathers, their great-grandfathers, their uncles, and in some cases their mothers, be convicted as an innocent person. And not everybody's innocent. I get it. I understand. I believe that crime should be punished. But the crime and the person who committed it needs to be punished. We should not afford innocence to suffer because we're trying to be tough on crime. It is not producing good results in our state. We have the highest incarceration rate, we have the highest crime rates, and it's tough on crime hasn't been working. I'm asking you to create a bridge of trust to show that we are seeing where we have made a mistake. People need to know that we care about their innocence, they care about their families. My fiance, both his parents passed away since he's been in prison. He did not get to go to their funerals. He was offered a Zoom call, and then the technology didn't work for one of the funerals. So there's so much pain that's escalated through people that are convicted that are innocent. His two boys grew up without their dad. So we're trying to protect society by being a little more strict on crime, but there's these rippling effects behind the scenes. We need to do it correctly. We need to do it properly across the board.
Thank you very much
so
for your
much.
testimony. Welcome to the committee. Please introduce yourself.
Thank you for giving me this opportunity to speak. Senator Bowie, Senator Duplessis, thank you. My name is Belinda Parker Brown, and I'm with Louisiana United International. We are a civil constitutional human rights organization, and I domicile in St. Tammany Parish. St. Tammany Parish was notorious for using this unconstitutional law to threaten and badger people to take pleas to things that they did not do. Walter Reed, Jack Strain, the sheriff, have since been to prison. I went and met with Warren Montgomery, has since transitioned, to talk to him in regards to how bad people were being treated up under Walter Reed's corrupt administration. They were told if they did not take a plea, they were going to be put in front of an all-white jury and given 25 years to life for smoking a joint, for snatching a purse. So most people would plead guilty that were innocent because they were afraid. We nicknamed it the 10-2. So I want to share something with you. I want Louisiana to heal. I have touched, hugged, cried, and seen the families suffer because of this. We have over 3,000 members in our organization. We have vetted over 800 cases that came out of St. Tammany Parish alone. And there's more. People have suffered. Families have been destroyed because of it. Louisiana got it wrong. It was unconstitutional. And when I shared with Warren Montgomery, he told me, he said, Ms. Parker Brown, we don't have the resources to vet all of these cases that was convicted up under Walter Reed's corrupt administration. It's up to our legislators. I looked at him and I said to him, I said, Warren, what if it was you? What if it was your father, your son, your mother? Would money be a problem? Would time be a problem? He could not respond. I had a vision of a beautiful waterfall, water coming down off of this big mountain. And besides, there were two hands that stretched out. And then there was a lot of hands coming out of this mountain. And I turned and I looked, and the beautiful waterfall turned to blood. I don't know what it means. But all I'm saying to you all today is do the right thing. Do the right thing. Uhuru, it means freedom. Uhuru means freedom. We can't wait. Our loved ones have suffered long enough. And I'm in favor of this bill. Thank you.
Thank you very much, both of you, for your testimony here today. If the Sergeant at Arms would get, I think I see Mr. Daniels here as we move to the opposition. We have two cards in opposition. The Honorable Christine Russell, District Attorney, Thibodeau in opposition wishing to speak, and Zach Daniels, Executive Director of the Louisiana District Attorneys Association, in opposition wishing to speak. I would also like to thank all of you for your attendance and participation today. We do have 43 additional cards in support not wishing to speak. And rather than I butcher the names on 44 cards, we'll enter all of these into the record with today's bill as well. We have one card in opposition not wishing to speak, Billy Joe Harrington, the District Attorney from Natchitoches, Louisiana. Welcome to the committee. Please introduce yourself for the record. You may begin in whichever order you would prefer.
Thank you, Mr. Chairman. Committee members, Zach Daniels, Executive Director of Louisiana District Attorneys Association, appearing on behalf of the District Attorneys of Louisiana to oppose Senate Bill 218. I've been listening in the hallway. The room is obviously very full, so I will try to respond initially with where our opposition comes from, but also respond to some of the claims or comments that I heard during the presentation of the support of this bill. I've hoped to summarize multiple DA's testimony, multiple DA's responses as they're texting me, as they're responding to this, so that we don't have a continuation of multiple people in opposition saying the same things. So I do hope you will bear with me, and certainly I'd be available after that to answer any questions you may have. The Louisiana District Attorneys Association has opposed the outright post-conviction relief for non-unanimous juries. I think it's been run for 4 or 5 years, and our opposition is multifold, one of which it was stated should not be the primary objection, and that being cost or burden, and that is not our primary objection. I think it is a factor that must be considered because these are not simple cases in most situations. These are your most serious cases, your most complicated cases that proceeded to trial initially. Usually they're going to involve cases with a victim, cases of homicide or rape. And so at the starting point of these cases, they were complicated to begin with. As they grow, as they expand, as the direct appeal occurs, and the Louisiana courts look at this even with a non-unanimous conviction and still uphold the conviction, that continues to grow the case and the case file and the complexity of the case. Additionally, I think there's a fundamental disagreement at the outset of non-unanimous juries as a discussion. And that comes with the idea that all non-unanimous juries represent a manifest injustice. The Louisiana District Attorneys Association and the DAs around the state disagree with that assessment, and the example I'll give is from my own practice. This is a very common example when we discuss it among our membership, and it's a jury which comes back non-unanimous, but it comes back non-unanimous with two people not voting not guilty, but voting for a higher charge. Louisiana is a responsive verdict state. That means if you begin your case as a first-degree murder, the option the jury has there is to vote guilty of first-degree murder, or guilty of second-degree murder, or guilty of manslaughter, lesser included offenses within the crime of first-degree murder. And the case I will point to is one which on appeal had enough evidentiary strength that the appellate court pointed to it in denying my request. They said that this case in the First Circuit, there was no doubt as to his guilt. It would be the state of Louisiana versus Blason Fife, who was convicted twice of breaking into a man's house in Walker, Louisiana to steal his guns, steal his money, and killed him with his own weapon. There was DNA evidence. There was cell phone evidence. There was corroborating testimony from co-defendants who were induced to testify against him. There was a partial confession to the case, indicating his involvement with the underlying felony, breaking into the house, which in my mind satisfied alone the burden to prove the felony murder. He began his case as a first-degree murder, came back as second-degree murder, and one of the rare occasions that we have as prosecutors is after a jury comes back with the juror's permission and with the judge's permission, we're able to go talk to them. And my first question after getting this conviction for second-degree murder was, what did I do wrong? What could I have done better? I believed it was a first-degree murder. To this day, I believe it's a first-degree murder. The two jurors in the 10-2 verdict said, we didn't think he was not guilty. We voted for first-degree murder. The other 10 voted for second-degree murder. We were not required to become unanimous. Therefore, this was the verdict that we had. The First Circuit Court of Appeal, in oral arguments, I pleaded to them, even going so far as voluntarily obtaining an affidavit from one of the jurors to enter into the original court record to say that they voted for the higher charge. I said, please, look at the details of this case, look at the strength of the evidence of this case, and consider an exception to Ramos where we can prove that this is the factual situation, that jurors are voting for a higher charge, not guilty. They are voting some level of culpability, oftentimes even higher levels of culpability. The First Circuit said there is no debate as to the strength of the case. There is no technicality in the Ramos decision that allows us to consider that evidence. Conviction reversed. So we had to start over. So I had to bring in out-of-state victims' family who had watched the person that killed their brother, the person that killed their uncle. They had to sit again in the courtroom with him as he was again convicted, now of a unanimous verdict. So at the outset, I would disagree with the original proposition that each and every one of these cases represents a manifest injustice. The responsive verdict system alone provides that these are not necessarily people voting not guilty. They are voting the way they determine they should in that instance, and we do not interview the jurors as to what the details of their vote was. So there would be no way for us to separate the cases which are non-unanimous with people voting not guilty and non-unanimous with people voting either for a higher charge or perhaps even a lesser charge. The other example I'll give you, because it was thrown out that this is a double-edged sword. We heard that phrase, I think, a number of times as I was listening to the grant of a new trial and the impact that that would have. The double-edged sword. It would work against the defense. It would work against the state. I will point your attention to one case that I don't think was discussed, and that's the Gasser decision. Louisiana State Supreme Court case 346 Southern 3rd 249. That case is exactly like the one that I described. It is a second-degree murder that was convicted of manslaughter. It was a road rage incident. Again, no question as to whether or not the person committed the crime, perhaps a question as to which crime they committed based on the vote. 10-2, and the state believed that the two people voted for the original charge. After the verdict was reversed, the state said, okay, let's look at this, let's look at what we can do, and we are requesting to prosecute him for the second-degree murder, to reset it to the pretrial stage as the proponents of this bill would describe. The Louisiana Supreme Court said, no, you are limited to trying him for that offense because despite the defect in conviction, you are not allowed to go fully back to where you started from. So the proposition that it is a double-edged sword is not one that I would agree with, and it is not one that continues throughout the argument against non-unanimous verdicts. I will say that in trying a case, in sitting down in front of a jury, presenting testimony, presenting witnesses, there is absolutely no substitute for live witness testimony. I would ask you to consider it as a hypothetical. I hope you will permit me, Mr. Chairman. Consider whether my presence today or the presence of any advocate that has testified would be as persuasive to you, more or less persuasive, as if they'd simply handed you a note saying the same things. I think you know the answer to that. There is no substitute for live testimony. So the idea that a 30-year-old case or a 40-year-old case where the witnesses are not available could be presented with the same strength, I would fundamentally disagree with. These cases at a certain age become functionally untriable. The point I'm trying to make there is that it is not a double-edged sword against the defense. The defense bears no burden of proof at all. So the idea that there may be witnesses that they would wish to call, they have no burden to do so. The state bears the entire burden of proof in every one of these cases. So again, we find at the outset original disagreements as to how the narrative is being presented. I will also point out several other areas of post-conviction relief law that I think are relevant. 926.2, Code of Criminal Procedure 926.2 allows those who are factually innocent of their crime to prove that to a court. That exists outside of any Ramos claim. Those whose DNA evidence has come to exonerate them, perhaps DNA was not available or the sophistication of DNA was not what it is today when they were convicted. They have an exception to file to have their conviction overturned in post-conviction relief. So again, those whose DNA has exonerated them, that is not part of this Ramos group that would be allowed a new trial here. Those who can prove they are factually innocent, that is not part of the Ramos group that is part of what the bill talks about. This would be an open grant of a new trial for these folks. And I hear the phrase, petition the court, review the case. I would fundamentally urge that the post-conviction relief structure does not ask a judge to do that. There would be one factual finding and one factual finding alone under this law which would be relevant. That is whether or not it was unanimous or not. Not why it was non-unanimous, not the strength of the case. So it doesn't actually matter if there is a clear and convincing standard in the bill. I understand why it was put in there. But once it is established that it was non-unanimous, the court does not hold discretion in granting relief. The district attorney has no role in terms of waiving procedural objections, in terms of arguing an evidentiary burden. Perhaps if there is a rare case where a record is unclear as to the polling, that is where we would get into a gray area. But once it is established that these are non-unanimous, that is it. A new trial is granted. The discretion would pick up with whether or not to prosecute these, and a number of cases I think would fall into an unfortunate triage. I can't speak to what happened in other states that have looked at this, namely Oregon. I can't speak to how their courts have done it. I can't speak to how their district attorneys have done it. I would urge you to look at Louisiana's court system rather than use another state's template. What I will say is that if each one of these cases, and we may need to talk about the numbers, but if each one of the cases on the number or volume that we can't agree on were granted a new trial, these are the oldest and most complicated cases, and the current outset we are riding while crime is down, and I'm very proud to say, especially in cities like New Orleans, where Jason Williams, I think, has been working hard with state leaders to address crime. Where crime is down, we are still in the court system 2 and 3 years behind in addressing that. So we are still flooded with the rise in crime we saw in the post-COVID timeline. What that means is all of these cases will fall into not an assessment of strength of case, but raw ability of a district attorney's office to address the ongoing and current cases, which have become more complicated, more burdensome evidentiarily as technology develops, with cases that are 20 and 30 years old and may not be provable. That is what we look at when we say there would be a burden. I will say we will have some disagreement as to the numbers in the, I believe, Mr. Ward with the Promise of Justice Initiative. We sat down with him. I will thank Senator Duplessis for the open door that he has offered so that we could voice our concerns in anticipation of this hearing. I will thank the chairman for also participating in that, mediating, if you will, to opposing sides, because what I think we do need to understand is a gray area that is hard to overlook. The number 773 was thrown out as to the number of cases this would impact. Again, I can't tell you that is accurate or not. I will say that internal polling from our members revealed large discrepancies in those numbers. The Promise of Justice was kind enough to share those numbers, and I will state, I hope they don't take umbrage with this, that they found an inability based on attorney-client privilege to share the names. So it would be difficult to compare apples to apples with the polling we were able to conduct of our district attorney's offices. But in terms of just starting with Caddo Parish, who was able to report, we were told by Promise of Justice Initiative 88 cases. Their appellate division tracked 185 cases. We got about 19% of our offices that were able to dig into their records and look. And I say dig because the reason the number is so hard is there's no internal tracking system to flag these cases when Ramos was decided pre-Ramos or pre-Edwards when we didn't know if it would be retroactive. Not every office took the same approach in how you keep track of the filings. At the time, I was the Chief of Appeals in the 21st Judicial District, which is Livingston, St. Helena, and Tangipahoa Parish. I will say that I think we got between 30 and 50 filings, a full third of them. 1/3 of the filings were factually unanimous juries. But they filed for post-conviction relief. So again, the number we could quote could be as high as 1,600. And I will quote page 7 of the Promise of Justice Initiative's amicus brief in Edwards v. Vinoy, the federal case that looked at the retroactive application of federal prosecutions that were non-unanimous. And I will say that their number, it was 1,677 in that amicus brief. I will say, in full context of the paragraph, it was described as about 1,700, including those on appeal and those in post-conviction relief status. So again, comparing apples to apples is difficult when we look at this. We reached out to the Clerk of Courts Association and the Department of Corrections to see who, if anybody, could have properly flagged and identified these cases for us as they were filed. That does not exist. As a non-unanimous verdict was rendered 20 years ago, there was no special flag that was put on it. There was no special indicator besides manually looking at the court record. So I bring this up because what we run into is a difficulty in assessing that burden. And while the district attorneys feel that the number of convictions that we see where the verdict was non-unanimous do not necessarily represent not guilty verdicts, we do also look at the burden, the financial cost, and the triage which would take place. So in looking at the 1972 Apodaca decision, the position was that we were told what the rule was in 1972. It was challenged repeatedly over the last 50 years, and repeatedly the Supreme Court declined to change the rule that we abided by. Finally, what I will say is that even when Ramos was up on appeal, there were homicide cases in which the defense bar began preserving that objection. We object to the instruction that it can be non-unanimous because they believed it might preserve that argument for their defendant on appeal. There were also defense attorneys which would approach prosecutors, myself included, so I am speaking from experience, that said, Zach, can we please mandate that it be unanimous? We believe Ramos is going to be decided favorably. Most people were looking at it very, very carefully and couldn't tell you. My response, and the judge I was in front of's response, was I think that was reversible too. He would not allow us pre-Ramos to have a pre-2019 case decided unanimously, even if both the defense and state were asking for it. So we were in the most precarious catch-22 we could have been in. We could do nothing to correct it, absent what the legislature had done prospectively only. And in looking at how it exists as a problem now, what we see is a disagreement into the scope of the problem, a disagreement into the nature of these cases, and a disagreement as to the remedy that should be available. The grant of a new trial is a remedy that the district attorneys disagree with. So I'm happy to answer any questions you have. I realize I've spoken for quite some time, and I thank the chair and the committee for their patience in that statement. And I can turn it over to Ms. Russell for any additional comments.
Okay, thank you very much for your testimony. Perhaps we'll take Ms. Russell's testimony and then go to questions.
Good morning. Christine Russell, President, Louisiana District Attorneys Association, also District Attorney of the Parish of Lafourche. You know, I contemplated whether or not I was going to take the table because as a district attorney, I never want to testify against certain individuals. And I don't feel like that's why I'm here, but I felt compelled because there is another side. And I don't want to take away from any of the things that you heard this morning because they're passionate and I appreciate where they're coming from. But there is another side to it that I think we need to discuss. I have spent 20 years as a prosecutor fighting for children, and the cases that I handled were child abuse cases and some of the worst in our parish, and that's sort of what I focused on for 20 years. And those cases are different. They're not like a homicide case or other kind of cases that you deal with, because of course we're dealing with children. And preparing a child for court looks a lot different than preparing an adult. And I would bet probably if I asked any of you to walk into court and testify, we all still get nervous as adults. Well, for 5 and 6 and 7-year-olds to do that, it takes a lot of work on our part to work with children, especially to make them trust us and to let them know that even though they'll face their the person that did them harm, and maybe it even is a relative, that at the end of the day, Ms. Russell has them and will make sure that they are safe. That takes a long time to do that. Those cases sometimes took me a year to get them ready for trial if we could not work a plea bargain out. I had children that before trial were pulling their eyelashes out because they were so afraid of walking in that court and having to look at the accused and testify. And I can go on and on about my cases where children, one came in and was speaking in a British accent. The trauma was so bad for her to go in. And so I say all that to say, at the end of the day, I think back to my cases that were non-unanimous. And when I spoke with the jury after, oftentimes in what Mr. Daniels had alluded to, it wasn't about guilt or innocence. One case was about whether or not she was 12 or 13 at the time, and that would affect sentencing. One, they wanted to vote guilty. He was an older gentleman. They sort of felt sorry for him. So they were wondering if they can find something where he would serve the rest of his years in jail as an elderly person and not do a life sentence. But never in my non-unanimous verdicts was it a not guilty. Those individuals sort of stopped deliberating at the time. And so I think, and the reason I felt so compelled to take the table is I think back to those cases with those children, of now having to go back and say, despite all that I told you, and despite at the end of the day when I brought you in and said, you're a hero, you've protected so many children by taking that stand, I'm so proud of you. And now we move on to that word that nobody, and I'm sure everybody in this room understands, there's no closure. We use it all the time. There is no closure for them, but at least they closed the book. I can't imagine now going back to their parents or going back to them, and some of them are adults now, and say, I know they're guilty, I know they said he was guilty, but we have to do it all over again. And I don't know how we would ever do that for those children. And so there is another side to this. And I agree with Mr. Daniels, the conversation has to continue because as written, this is not it. This is not the answer because there is another side and it's gonna affect so many people who at the end of the day, those defendants were guilty. That is not what the jury was considering at the time. So I appreciate you allowing me to testify today. Again, I just felt compelled to make sure that I was a voice for those children today. And if you have any questions, I certainly would answer them.
Okay, I thank you for your testimony as well. We'll begin questions with Senator Bowie.
Thank you, Mr. Chairman. Your name again, sir?
Zach Daniels. Please call me Zach.
Mr. Daniels,
Yes.
thank you. I appreciated your testimony. You said a couple of things I needed some clarification. You articulated what, in my opinion, would be the process or the scope of the burden of the state to deal with these cases. But as I understand this bill is just to provide an opportunity of petition of post-conviction consideration. And so if among those cases, and I heard what both of you said about the other individuals that are involved, but what about those individuals who were convicted and were innocent? And so just to consider to deal with justice, the scope of work should not be an issue. The cost should not be an issue because we're dealing with lives and innocent lives if among those who may be found to be that way. But if we do not afford the opportunity, we close the doors of justice that are the result of a system of racism that created this problem for us, that we now have the opportunity to address, to see if we can truly provide justice for everyone, notwithstanding the victims of those who are guilty, but in particular of those who are innocent. And so for me as a legislator, if the court says this is up to the legislature, I feel it is incumbent upon legislators to do the right thing for Louisiana. And regardless of what the scope of work might be for the state, we should take that upon us and do what is right to move this state forward and end any vestige of those kinds of victims that have come from an unjust system. So I appreciate the conditions you identified that would be difficult, but it's something we must do. DAs, you took that on as your job, to deal with justice, just as we took this on as legislators to represent the citizens of this state. And to shirk that responsibility for any reason because it is difficult and complex is unconscionable, in my opinion. Thank you, Mr. Chairman.
Thank you, Senator Bowie. We'll now move to Senator McMath.
Thank you. Thank you, Mr. Chairman. Both sides of this testimony I've heard today have been compelling. So I want to thank everybody that came and spoke. Zach, Mr. Daniels, in the case, the Walker case that you cited, where two of the jurors thought that it should have been first-degree murder for a second, and if we applied this to that case, first of all, what was the sentence for that the person who
Life.
Okay. So my question earlier to the other gentleman was, in that instance, because that wasn't a non-unanimous jury, but yet that individual is still serving a life sentence, is the DA, practically speaking, going to bring? I mean, what would behoove that district attorney from retrying that case, knowing that individual and spending the time and the resources that you guys are concerned about, and I can appreciate that. My district attorney, who's a good friend of mine, we're in a little bit of a budget spot in St. Tim in 22nd JDC, so I can appreciate that side of it. Although I don't think, and you said this in the beginning, resources and time shouldn't be the driving factor. A factor nonetheless, but not the primary concern, because if there's just one Mr. Evans, who I met with last week, an innocent individual still in prison, I mean, that's not an excuse for me. So use that case. What would happen there?
It did happen, sir. So we were fortunate in terms of the date of offense. The Fife case, if I refer to it, that would be the defendant I described earlier who broke into that Walker home, that he had proceeded pretty quickly from date of offense to trial on the first go-around, 2017 to 2019, which sounds like a long time, 2 years, but is actually relatively quick for a homicide case. It was pending appeal, and one of the more frustrating parts about that is there was a delay in the transcription, which stretched out the appeal several months so that it was still on appeal when the Ramos case was decided. The decision that has to be presented, because it is overturned. The conviction was overturned despite the strength of the evidence that the appellate court noted. The decision had to be made, do we look at this case and say it can be retried or it can't? Well, with a short timeline, that initial threshold is a little easier. Yes, the witnesses are all still alive. We are less than 5 years away from the original date of incident. Should it still be retried? It is a vicious and violent crime. That is a lower threshold as well, yes. Financially then, and again, this is not the primary focus, but it's a consideration for any of it, is the thousands of dollars the clerk of court has to do to get jury notices sent out and jurors brought in. For cell phone cases, the thousands of dollars the DA's office had already spent on an expert, we would have to spend again to secure their testimony again, because again, while it could be read into the record, there's no substitution for in-person testimony in terms of strength of the case. The decision was made by Mr. Perilou in the 21st Judicial District to retry the case. So again, we were able to get through the harder decisions faster because it was a younger case. For a case that is 30 years old, that initial threshold, fundamentally, logistically, can this case be retried? Not money-wise, but are the witnesses still alive? Is there an ability to get them to come in? And the hypothetical I give to jurors, Senator McMath, is as you backed out of your driveway the last time you drove, do you know which direction you normally turn out of your driveway? Okay, the last time you backed out of your driveway, what was the first car you saw driving on the road? Do you remember it? Most of them don't, because you're not paying attention. You're fiddling with your phone, you're putting directions in, you got the radio going. The point I make with that is that witnesses lose memory. It is nowhere near as fresh to them as the moment they were victimized, when they were raped, when they were robbed, as 30 years later. There's no comparison. And so where that occurs, where the evidence, the memory has degraded, the state's case is degraded. So those initial thresholds of can we try this and should we try this will become extremely problematic the older the case gets. In terms of
I recognize again that it's hard.
Sure.
I get that.
In terms of addressing, I think you mentioned a gentleman who was factually innocent that you met with. Again, very persuasive and horrifying to hear of. But that exists currently. Under current law, a person who is factually innocent, who is serving time in jail and factually innocent, has an avenue for post-conviction relief. Same thing with DNA testing that would exonerate a person. That exists now.
Yeah, but the Supreme Court ruling in 2018 and 2019, or whenever it was, that declared non-unanimous. I mean, that's why we're even having this discussion at all. So I don't know if it's apples to apples. In my head, I almost feel like we're trying to, pay for an original sin in a sense. And so how do we right that wrong? And it just feels like the the plan is to sort of say it's really too hard and bury your head in the sand and.
No, sir, and the avenue.
And look, this is not you. This is not an attack on you. This is a very difficult situation that the state, us, have found ourselves in. But I don't know how you get past the fact that if there's just one innocent person serving time for a crime that they didn't do, like, I don't know how you sort of justify the rationale that, man, this is going to be really difficult to do, and so we shouldn't do it. I don't, you know what I'm saying? And really, I guess I'm thinking out loud. But yeah, I guess this, because of the factors that you bring up with the individual cases and the time that's lapsed. There's got to be some sort of way, whether I know that we don't want to. There's concern about setting up another, commission or some sort of group that explores this. But I would just really, really encourage everybody, and maybe this isn't done this week. Maybe this is something that we try to find some sort of solution on. If because look, just being honest, politically speaking, I don't think that this as is. I could be wrong. It could have a change of people could have a change of heart, but would pass the floor if it were to get out of this committee. But if there's something else that we can try to work on, maybe for a week, and not to kick the can down the road, but. Because I don't, we did this last year and I didn't like it, and we're doing it again this year and I don't like it. But I signed up for this job, nobody else did. So I don't know if there's a possibility or an opportunity to try to move the ball some shape, form, or fashion that we can come up with some sort of procedure or process to better vet these cases so that it's not overly burdensome to the DA's office. But again, I don't know. That's not a good enough excuse for me just to ignore the fact that there could be just one more Mr. Evans in prison. So that's all I have to say.
Thank you, Senator McMath. And before I go to our next question, that's kind of what I've voiced in multiple meetings with you guys as well. If not this, what? And if not now, when? And that's really a challenge I place on you to light a path forward. I share the sentiments of my colleague, Senator McMath, and the passion of my colleague, Senator Duplessis, that we do get this right. And I fully understand the complexities placed on the prosecuting side of these cases. But what can be that path forward? And we'll continue this discussion here today, but I would like to continue it beyond this committee as well to determine what can be a proper vetting process. How do we further narrow down maybe the cases that don't have some of the scenarios that you well indicated and rightly indicated. So just a challenge from my perspective. Senator Duplessis.
Thank you, Mr. Chairman. I just have a few questions that I'd like to offer and discuss as we, find ourselves back here again this year, as we've been here in previous years. I want to thank Madam DA for being here and sharing your perspective. And I want to, like you, start with the victims and the horrible instances that all the victims that you represent and have represented in their experiences that they've been through. I've always believed that the best way that we can serve those victims is ensuring that the actual offender is the person who's actually brought to justice. And we do an even greater disservice to the victims that we want to protect by not ensuring that the person who actually carried out the offense is the person being brought to justice. And the victims just aren't on one side. This system that has plagued our state for so long victimizes everyone. And we remain victims as long as we have this non-retroactivity in place. And I want to state that, and I hope you all understand where I'm coming from when I say that. There are families, there are stories, there are cases that we haven't even heard of, we don't even know, right? There are more Herman Evanses. There are more Jermaine Hudsons. They are victims. Their families were victims and remain victims. So let's just make sure that we see the bigger picture. And we share the same desire to try to address this. I think we share a fundamental disagreement on how we go about doing it. Mr. Daniels, you have done this work. You were a post-conviction appellate lawyer, correct?
Yes, sir.
So I know that we spent a lot of time, many hours, a lot of meetings talking about this, and you know, we get bogged down in a lot of the jurisprudence and technicalities of all of this. But fundamentally, U.S. Supreme Court made its ruling. The Louisiana Supreme Court made its ruling. Have either of those courts, from your understanding, said that this is something that we should not take up as a legislature?
I believe they described it in terms of what is called the Teague rule, which is retroactively replacing a procedural rule with a newly developed rule, and they said it did not rise to the level of material injustice sufficient to make it retroactive.
No, that's not my question. My question to you was, did either court say that we should not address this issue? Did they take it out of the hands of the legislature?
No, sir.
Okay. And by not doing that, I believe they left it in the hands of the legislature to correct it. Do you disagree?
I think that would be a direct quote almost from the most recent
That it's up
case,
to
I
the
think
legislature.
Reddick,
That's
yes, sir.
For us to do. So so we agree on that. That it's up to the legislature to solve this. Because you mentioned the numbers and that you have some questions around the numbers of the actual cases that may or may not be out there, you questioned the numbers that PJI presented to you, but you did not provide any numbers to suggest that that you had your own numbers to verify the actual numbers of non-unanimous jury cases that are out there.
Yes, sir. Unlike what I would describe as calling a prosecutor and asking him, hey, can you tell me exactly how many cases you have pending? He can do that relatively quickly. Unlike a defense attorney, and I've never done criminal defense work, but I assume that they could tell you with some level of accuracy, relatively quickly, how many clients they have active right now. That's how they get paid. Public defenders, based on my personal knowledge, have some case tracking system that allows them to get to that answer very quickly. What we are trying to do is identify a subset of cases, so not filter it by any metric that we've needed to do so before, but trying to figure out based on allegations that have been raised. And I quoted earlier the Caddo Parish numbers. The 185, they may have seen the same thing I saw in Livingston, where a number of people filed for post-conviction relief claiming they were non-unanimous or had non-unanimous juries, which was factually incorrect.
All right, so let's stop there.
Yes, sir.
Because you brought up Caddo. What's the position of the DA in Caddo on this issue?
I don't know that he and I have spoken directly on the issue. What I will say is, as a group, the association has met, our board of directors has met.
No, I'm just asking on Caddo.
Again, my answer would be I don't know.
You
that I've
represent the DAs, right? And that's, from my understanding, Caddo, just based on the numbers, are probably in the top 3 in terms of cases across the state that these non-unanimous jury convictions may have come out of, and you're saying you don't even know the position of where the DA from Caddo might stand on this issue. You represent the DAs.
If allowed to finish my answer, Duplessis, have you finished your question?
I'm asking you not the position of the DAs. I'm asking you about the DA from Caddo Parish.
Yes, sir. Our association is a consensus-driven group. What we do is we meet repeatedly, and we've met for years on this issue, debating it at multiple board of directors meetings. And what we do is find a consensus. Does that mean that every single district attorney agrees on every single position that we have? No. What it means is that once it is debated, we take 2 votes. We take a vote as to whether or not we should support or oppose a proposition. We voted to oppose this one. We then take a second vote to make sure that it wasn't a 51-49% vote, that it is not a simple majority, that in debating it and discussing it, we have reached a consensus as to how we feel. I will let you know that Judge Stewart and I have spoken many times about many bills. I cannot recall to you if he is for or against this specifically, but LDAA, as an association, has voted to oppose this bill.
Okay.
And every district attorney has the right to be heard at every one of our board of directors meetings.
And I'm aware of, my question wasn't about your process.
Yes, sir.
My question was very specific about one particular DA that you said you don't have any recollection of where this DA stands, and if that's your answer, that's your answer. But what it seems like to me, based on your internal rules as an organization, is that a vote is taking place whereby DAs who have fewer cases, if any at all, in parishes where there are no cases, are outvoting, or their votes are outweighing the parishes where the cases are primarily being found. That's what it appears to be. And I'm not a member of your association. I obviously don't go to your meetings, but that's what it looks like, which to me appears to be an injustice. But we will move on. And I think I only heard there was only one other card from one other DA from Natchitoches, Billy Joe Harrington, right? And I don't know how many cases are being alleged to have come out of his parish, because you're saying we don't have those numbers. But I think my point that I'm trying to get to is that I think we should be giving some deference and some prosecutorial discretion as an association, which you all say is a big tenet from the DAs where a lot of these cases are coming out of those parishes. But in these cases where an individual may or may not have a non-unanimous jury conviction, were these individuals ever offered a plea deal at any point at the origination of the prosecution?
What I can tell you is in the 19% of DAs that were able to review their files and respond timely on this bill as to how many PCR cases we have, I can't say that we've said yes or no whether Natchitoches Parish has these cases. And it would be impossible for me to tell you in the over 800 cases that we got from that 19% of judicial districts, it would be impossible for me to review each case and tell you whether an offer was made on them or not.
And I'm saying pre-conviction, not
Yes, sir.
post-conviction, whether or not a plea agreement was offered.
I would have to review the individual transcripts of each case and see in a pretrial status conference if it is transcribed.
Is it not custom when there are cases that prior to trial a plea deal is offered?
No, that is extremely customary. It's 95% of cases are resolved by way of a plea agreement. Understanding or assessing whether these cases were offered a plea, to do that, I would either have to read the transcripts of each hearing on each case. If the notes of an assistant district attorney or defense attorney were accessible, reviewing them may do it. Some court minutes would reflect it. So it would be a detailed review of each and every one of these cases, perhaps better directed at a person who represents a defendant making this claim rather than myself, as I don't have access to any of the materials that we're talking about.
Okay. You mentioned the disadvantage that the state would have in the event the witness not be available, isn't available. The witness is either deceased or, as you said, time has gone by, so their memory has deteriorated. In that case, does the state not have at its disposal the ability to read in the testimony from the trial where the conviction was obtained?
We would, subject to additional scrutiny and motion practice,
Right.
we would be
But
able to do that. And I
you
will
could use
say
that.
replacement for live in-person testimony.
That's an opinion. That's an opinion. I'm asking you a fact-based question. Your opinion is that there's no replacement for live-based testimony. Some might argue that a live witness, we don't know what that person's going to do on a stand. You don't know if they're going to be good or bad, and every attorney knows that before somebody goes on a stand. So that's your opinion.
I could articulate some case law for you if you would like,
No,
Senator.
sir. My question is whether or not the defense would be able to cross-examine that witness who is no longer available.
They would not, no, sir.
Right. So not being able to cross-examine the witness who originally testified at the trial, you're saying that would be a disadvantage to the state? I see it differently. Because if you can't cross-examine testimony, that means you have to take it as is. You have to take the transcript word for word, and you have no opportunity to cross-examine that. So how does that benefit the defendant?
Simply put, Senator, whether or not a person is telling the truth, I think, is a face-to-face assessment. So in an original jury trial where a jury is looking at a victim, a child victim, listening to them, assessing whether they're telling the truth, versus a clerk of court standing up and reading testimony, I would say it is almost impossible for a jury to say with any certainty based on someone else reading testimony that they cannot answer questions to, regardless of whether you wanted to ask additional questions from a defense standpoint. I would say that face-to-face assessment, as we look each other in the face, Senator, I can see the passion on your face. I am assessing your credibility the same way you are assessing mine.
You're talking about the same face-to-face assessment that the jury gave to Bobby Guntwright when Jermaine Hudson was convicted.
And again, the face-to-face assessment cannot be replaced by reading the same testimony.
All right. I want to talk about trust and the system that we're trying to uphold, and just your belief that as a system, the district attorneys, the sheriffs, law enforcement, the legislature, all the role that we play in terms of trying to restore trust so that the public can believe in the system. What role do you believe this plays in helping to restore that trust when we know that there are cases out there, and I believe this is the point that Senator McMath was getting to, we don't know the number, right? It's not a question of guilt or innocence. I'm not here professing this term that you were saying about, I think it was a material injustice or a manifest injustice. That's the term you were saying. What I'm trying to do is help to restore a level of trust in the system. And I'm asking you, how do we do that when we know that there are cases out there where people, whether it's one or whether it's 100, could have, and in many cases were likely convicted by a non-unanimous jury, and two people on that, at least two people, at least one person on that jury, for whatever reason, did not go along with the rest of the 10. What does that do for restoring trust between our criminal justice system and the public?
Certainly, I think that it is the twofold trust that you mentioned earlier, where you categorize the folks that have been the victims of an unjust system, that have been wrongfully convicted, that I will connect you to the victims of the crimes who have seen these convictions become final, that their trust in the system must be maintained in the same way that we replace or rebuild the trust that you are seeking to. And I would say we cannot have it be a binary. We cannot have it be a yes-no question as to whether there's a new trial. The path to parole that we have discussed a number of times, that would allow the body that is deemed by this legislature to have the ability to do that, whether that is a committee, a commission, an extension of the Board of Pardons or Parole, they would need to assess the cases themselves. Absent that, and the trial courts here, the district courts here in a post-conviction setting will not assess these cases. They will assess the one claim. Where we can build trust, I would say, and where the district attorneys have traditionally become neutral in the past on this, is where there is a path to parole. So I think Senator McMath voiced this in terms of where can we go forward. Senator Royce has challenged us as he did last year, and I would direct you to the discussion as it has developed in the offseason, is that the goals that we had in terms of bringing some form of agreeable resolution here include that path to parole, that assessment of the cases, that assessment such that the material injustices, the innocent people who we believe are serving in the Department of Corrections, can have their case addressed. At the same time, those that we as prosecutors would hang our hat on and say, I know that man was guilty of this crime because he said it was, even if it was non-unanimous. They can be assessed in the same fashion, and those that we have determined, or the board, commission, pardon and parole have determined are factually guilty, do not get thrown into the same category as those that you are trying to advocate for today, and I think doing a very good job for. I would again state that where we are able to have a review of the details of the cases, where we are able to have advocates either for the defendant or for the strength of the case through the district attorney, that path to parole would be where the district attorneys have traditionally become neutral. We were not presented with that in this offseason.
All right, we'll talk about that, because I'm about to bring my questions to a close. Earlier, when you were answering questions, you spoke, and you said it repeatedly. You said that you can't speak on behalf of another state. You can't speak on behalf of Oregon. My question is, did you do anything to try to reach out or learn what they did in Oregon, who was very similarly situated? They got to their outcome differently. I understand the courts basically did it for them. We didn't have that luxury. Now we have to do it ourselves. But my question is, you said you can't speak for them, but did you try to speak to them? Did you try to learn? Did you try to see what they did in Oregon?
No, and I can't tell you whether there is a me in Oregon. I may look like a dime a dozen, but I can't tell you whether there's
y'all
a
look
prosecutor's. Yeah, thank you. We do all look alike, yes, sir. Whether or not there's a prosecuting coordinator that could even assess and give a clear answer to that, I could not tell you. The shortest answer is no, and I would again focus that Louisiana needs to fix Louisiana's problems.
So a problem this grave that we continue to come back year after year, and I told y'all last year, this problem is not going away. Y'all can get rid of me, but y'all not gonna get rid of this problem. That you would not even take the step to investigate or look at what Oregon did and what challenges it may or may not be having of a situation this significant that it never even occurred to you to say, let me do a Google search or let me ask ChatGPT what's going on in Oregon. And I'm not trying to minimize it, but what I'm trying to do is illustrate my frustration, which I know you can see, right? Because I've shared it with you before we came to this committee today. I think it's unacceptable for you to say that we don't need to look at what Oregon did, right? When you can't even tell us how many cases there are or are not. And I think it's a slap in the face to this committee, because what it shows us is that you're not trying to solve the problem. And I think that's clear. Now, you brought me there, and I'm trying to find a solution. But the question is, are you? So to say that you didn't even take the step to look at what is happening in Oregon, I think we know all that we need to know. So my question is, and this is the question that the committee has to ask itself, because I know where I'm at on this. What are we going to do? Now, I'm ready to vote this bill out of committee. But if the committee feels like we don't have the votes, then we can continue to work to try to find a solution. But I think we see what we're working with. And I don't want to be right back here next week having the same conversation. I really don't. And we know where the state stands on this. I have support from Republicans. I have support from former NFL football players. This is a bipartisan issue, right? This is not an issue that people are divided on. If you put this on the ballot tomorrow, it would pass overwhelmingly. And I think it's a disservice to this state to have the head of the District Attorneys Association, respectfully, the president, who's doing her job respectfully, and one card from a DA in Natchitoches to say we oppose this, to stand in the way of the will of the people of Louisiana. That's not how it should work. That is not how it should work. And again, I understand the legislative process, but Chairman Reese, you did me the service of trying to push us to this before we even came into session. We had a call, and what you're presenting, we know where that's going. That whole parole option, that whole thing that y'all did in the House 3 years ago was a complete train wreck. And why would we go and create an entire new apparatus or layer of government when the courts are already prepared to deal with this? There's nobody better suited to deal with this than the courts. We have a post-conviction process in place, Mr. Daniels. So we're going to, that would be a total cluster. And it would be. It'll be a cluster. Well, I'm done. I think I've made my point. Look, we're cleaning up the mess back from the 1800s, right here in 2025. We're still cleaning up that mess. So you and the DAs today can decide to clean it up today or let the future DAs deal with it, right? I think we should go ahead and deal with it because the issue is not going away. Thank you, Mr. Chairman.
All right, thank you, Senator Duplessis. We have a question from Senator Talbot.
Thank you. I guess my question is to you, Mr. Chairman. Did any district attorneys put in green cards for this bill?
No.
Okay, thank you.
All right, the board is clear. Again, as we've discussed, I think clearly I have great respect for people that provide testimony both in opposition and support and respect their positions. I personally don't want to leave this session not having accomplished anything in this regard, though, as well. And I think personally, I feel like you bring up some good points, and that is, how do you ultimately vet how do you ultimately identify the cases that we're actually talking about that may be best suited for new trial versus, you know, the variety of issues that you indicated that you would find in a record to indicate that the question is not guilt or innocence. You know, the question is which charge would have been unanimous versus non-unanimous. You know, and how does the clemency process fit into that? How does the parole process fit into that? You know, I believe, along with Senator Duplessis, that we ought to make some progress on that. And if this bill is not it, I'd love to know at least a counter suggestion as to what would be more workable, because you do have an important role in this balanced form of judicial government that we have, right? So, anyway, with that said, the board is clear. We thank you for your testimony.
Thank you, Mr. Chair.
We have 6 emails in support that I'll turn in for the record, as well as 1 additional green card from Zara Johnson, rather. That was during our other testimony. Okay, so what is the pleasure of the committee? We can either take this up today for a vote. We can continue to consider it and promise an allocation on the next agenda to this bill as well, Senator. Okay, Senator Bowie's going to move that we report the bill favorably. Is there any objection to that motion?
I'll object.
All right, Senator Talbot has objected to that motion. Madam Secretary, please call the roll. A vote yes is to report the bill favorably. A vote no leaves the bill in committee.
Senator Bowie?
Yes.
Yes. Senator Duplessis?
Yes.
Yes. Senator McMath?
Yes.
Yes. Senator Owen? Yes. Senator Talbot?
No.
No. Senator Harris? Yes. 5 yeas, 1 nay.
To be clear, we're not allowed to have those kind of vocal responses in the committee. We thank everybody for their participation today, and we'll move on to our next bill in the agenda.